Hello and welcome to TNR Live. I'm Matt Ford. I'm a staff writer at the New Republic where I cover law, the courts, and democracy. Thank you for joining us today for our three-part series on Supreme Court called Supreme Court Watch. Throughout the month of June, we will be bringing you breakdowns and analysis on key opinions as the court enters its final month of the term, what they mean for you, and what they mean for democracy. This court's term is extraordinary because it's been overshadowed somewhat by ethics controversies and recusal concerns. And there have been calls for reform about this by Democrats on Capitol Hill. Foremost among them is the senator joining us today, Senator Sheldon Whitehouse, a Democrat from Rhode Island and a senior member of the Senate Judiciary Committee. As chairman of the subcommittee on the federal courts, he's been an outspoken leader on the push for Supreme Court ethics reform. First of all, thank you for joining us today, Senator. I think we're having a slight audio issue.
You're not hearing me? My mic is on.
Now I can. Perfect.
Maybe somebody on your side didn't switch me on.
Sorry about that. Well, thank you for joining us today. I want to start by saying, when I was researching for this, I came across a quote in a Wall Street Journal op-ed by their editorial board. They're fairly conservative. And they sort of described you in passing as long overdue for the fitting of a tinfoil hat. Do you feel vindicated at all by these recent disclosures?
I mean, yes, horrified also, but it does feel that there are a lot more people gathered around looking at this mess than just me. And I think the opportunities now for reform are improving because the problems are so obvious. And I'm actually quite hopeful because I think that within there is the Judicial Conference, which is the top administrative body for the federal judiciary. And I think those judges know better than anybody that the conduct that's been recently disclosed about the Supreme Court is unacceptable and needs repair. So when the judges get that and start to put pressure on, I think there's a pretty clear pathway to real reform.
And just to set the stage here, you've been talking about Supreme Court ethics reform for a long time. I've seen you bring it up in confirmation hearings for many of the current justices. How did this get on your radar?
Well, believe it or not, it actually began when I was trying to figure out what went wrong with climate change legislation. And you can pretty much chart the end of bipartisanship on climate change to the announcement of the Citizens United decision, which allowed unlimited amounts of anonymous money to flood into politics, which was the fossil fuel industry's vehicle for shutting down bipartisanship. And as I began to look over at the Supreme Court, I began to notice the overlap between the front groups and the individuals, the mouthpieces that were involved around the Supreme Court and that were involved around the climate denial operation. And as the Supreme Court began to behave more and more weirdly, and as their decisions took on more and more of a partisan pattern, the piece together very clearly.
And you've described this as the court that dark money has built. And I
Yep.
know that people understand that maybe from an electoral context. They see ads, they see flyers. What does that mean for judicial confirmations? How does dark money influence that process?
Pretty heavily. I mean, if you look at the so-called Supreme Court list that supposedly the Federalist Society developed for President Trump for his Supreme Court nominees, the Federalist Society has actually itself pointed out that it had no proper proceedings related to any such list. It had no decision that it made in any, corporate act of the Federalist Society. This was something that was cooked up in a back room someplace at the Federalist Society, perhaps, but cooked up by dark money interests, dark money billionaires. So you begin with candidates who've been pre-selected by dark money. Then you see the ads go up to support them. Those ads were usually paid for by something called the Judicial Crisis Network, which took huge, like over $10 million plus individual contributions of dark money to fund those ads. And then you've got political support through dark money for Republican senators who clear the nominees. And then they get onto the court, and you now have flotillas of front groups that appear as what are called amicus curiae, friend of the court, to file briefs by the dozen dark money selected justices how to rule. And then at the end, you get that pattern of virtually complete adherence to the recommendations of the dark money front groups.
And this is something that obviously really took off during the Trump administration. We've seen this because, he appointed a third of the current court. He appointed a huge number of lower court judges. But this sort of has its roots in an earlier phenomenon on the right. Is that correct?
Yeah, I mean, it became flagrant in the Trump administration, and particularly because Trump was so indiscreet about saying what he was doing and why he was doing it. But, it goes back actually quite a long ways. The guy who was the sort of fixer and operative for the billionaires is an individual named Leonard Leo. He established his cred with right-wing billionaires when he helped them orchestrate killing off the candidacy for the Supreme Court of Harriet Miers. Harriet Miers was the appointee of President Bush. She was a conservative. She was a woman. She was a personal friend. She was his White House counsel. So for a whole bunch of reasons, she looked like she was probably going to be good to go. But the billionaires, using Leo as their fixer, got involved. And President Bush had to humiliatingly withdraw his own White House counsel as a nominee for the Supreme Court. And instead, they put up, guess who? Sam Alito. So that was the big sort of cred moment for. They had other disappointments in not getting Bork. They had the game plan going back to the early Chamber of Commerce report on how important it was to capture the judiciary, written by the guy who became Justice Lewis Powell about 4 months after he wrote the report. So there's a long thread of this, but it became particularly flagrant when Trump was president and he was doing exactly what he was told by the billionaire backers behind Leonard Leo.
And you've introduced a bill, especially with the recent news about Harlan Crow and Justice Thomas going on vacations with him. You've reintroduced a bill to sort of address Senate or Supreme Court ethics reform. What exactly does that entail? How does it tailor to the problem at hand?
Well, the most important thing that needs to be done is to have a procedure for evaluating whether an ethics violation has taken place. There presently is no procedure at the Supreme Court. It's different in that regard from every other federal court. So if you have a complaint about a justice, there's no inbox to send it to. Because there's no inbox, there's nobody behind it to sort out reasonable and credible complaints from just, nutty stuff. And once you have reasonable and credible complaints, there are no staff attorneys to do any investigative work and actually come to a resolution. And there's no independent body to evaluate whether or not the facts as determined by the staff attorneys constitute an ethics violation. None of that. It's all standard procedure in all of the other federal courts. And that allows the justices basically to either make up their own outcomes or simply refuse to provide the facts that would determine whether or not there's been an ethics violation. So the most important thing is that there has to be a process. Then, their rules should match the rules for members of Congress and senior executive officials. And this business of the phony front groups coming in and filing briefs without saying who's really behind them, there's actually a rule about that. And that rule should be strengthened and actually properly enforced so that everybody else knows, who's in the courtroom with them. So we try to cover all of those areas in this bill: recusal, transparency, disclosure, phony amici, and a proper procedure.
And as part of this, I know the Senate Judiciary Committee has asked Harlan Crow to supply more information about his relationship with Thomas. He has declined to do so. What are your next steps there?
So we have written back in response to his lawyer's response to us. The lawyers basically said, "You have no business here." They went on for 6 pages about how Congress has no business here. There's a separation of powers bar that prevents us from looking into this. Across those 6 pages of legal verbiage, they managed to never acknowledge that the body responsible for this ethics enforcement is a body Congress created. It's called the Judicial Conference. And the ethics disclosure rules that the Judicial Conference is supposed to implement are laws passed by Congress. They're our laws. So the notion that Congress has no role in overseeing how a body that Congress created is implementing laws that Congress created is really nonsensical. So we gave them a second chance to try to write back to us with a nonsensical response. That's due, I want to say, on the 5th of June. So we'll know soon what the reply is like. And then we have, other remedies to pursue our investigative and oversight responsibilities.
What happens if we get into a situation where the Supreme Court doesn't seem that interested in following Congress's lead on this? We've seen from Justice Roberts, he's emphasized recently that he thinks this is something the court, as a co-equal branch of government, should be doing on its own, that this is its own responsibility to police. How do you respond to something like that?
Well, I think that there actually is a prospect for the judicial branch to solve this problem, again, through the Judicial Conference. The court itself has shown no willingness to treat these ethics problems at all seriously. They won't come over and testify. We get low-level letters from functionaries in response to what I consider to be fairly serious requests. They don't go through even the performance, like they're taking ethics concerns seriously and providing factual responses. The whole thing is just completely a mess. And against that mess at the Supreme Court stand all of the other federal judges who know perfectly well that what the Supreme Court is doing is not acceptable conduct for a judge, who know perfectly well that it's policeable because they police it in their own courts, and who I think are coming to resent the excuses of the Supreme Court that there's nothing to see here, folks, just move along, because that suggests that the behavior is proper. And that in turn suggests that that improper behavior might actually be done by other judges, that this isn't just a Supreme Court problem. So I think it's the other federal judges on the Judicial Conference who are pushing back. And that may explain why Chief Justice Roberts just the other day, for the first time, acknowledged that there's more that they need to do to clean up the court's ethics mess.
And we know from recent polls that, especially after Dobbs, the court's public perception is certainly declining from recent years and certainly from all-time highs. I noticed that you're pretty outspoken about this.
It's ridiculous. If you're a municipal employee in a small town in Rhode Island, you're not allowed to take lunch with somebody without reporting it. And once you've taken 3 lunches that add up to more than $75, you can't do that any longer, even if you report it. So all across the country, in the local government, in county government, in state government, throughout the federal government, you have employees who are held to fairly sober ethical standards. And then you hear about a Supreme Court justice who, unreported, is getting multi-$100,000 vacations, who's having his mom's rent paid for, who's having the child that he's raising's education paid for by a right-wing billionaire who's politically active and trying to manipulate the court. There's just no way that that is acceptable by any reasonable standard.
Do you think Democrats have been vocal enough about this? Do you think they're ahead or behind of the public curve on this?
Behind.
Why do you think that is?
I think that the Republican Party both learned that the Supreme Court could be a big political issue for its base and helped create the Supreme Court as a big political issue for its base. Back in the 60s and the 70s and the 80s, they didn't like Brown versus Board of Education. And as you know, there was that revolt throughout the southern states. There were impeach Earl Warren bumper stickers. They didn't like Roe versus Wade. They didn't like the criminal law rights cases. And so they turned all of that into a means of cranking up Republican base voters. And Democrats kind of didn't care. And as we waited for the capture of the court being built, I guess it was hard for us to believe that this was really going to work out this way, that they were actually going to be able to capture the United States Supreme Court the way, railroad barons would capture an old railroad commission back in the 1800s. So we were slow to the mark, but now I think the Democratic voters are more and more concerned. I think independent voters are extremely concerned. And I think the record of the court shows that it's gone badly off the rails and that there's actually more than just public concern here. There's an actual problem at the heart of it.
Do you get the sense that the Biden administration is also a little reluctant to discuss these issues? I noticed that Biden, he himself is familiar with these. He's a former Senate Judiciary Committee member himself. He doesn't seem to be willing to address the court as bluntly as some of his former colleagues on Capitol Hill may want to. Do you sense any sort of movement on that front among him and his staff?
I don't yet. I think you're right. The whole Biden administration has been exceedingly reluctant to tangle with this issue, even to the point where when they set up this so-called commission on the Presidential Commission on the Supreme Court, the folks who saw things my way, who listened to the evidence that I presented, very well-respected people, Judge Gertner, retired U.S. District Judge up in Massachusetts, Lawrence Tribe, renowned constitutional law school, they were not able to put their dissenting views into the actual report of that commission. They had to launch them in an editorial on the same day that the commission report became public. But ordinarily, you think that if you have a commission and it has members who have dissenting views, you put them in the report as dissenting views. And the fact that they had to depart from the commission to have their views heard at all by writing them in an op-ed in a newspaper shows a very, very significant reluctance to deal with the real problems that are around the court.
And that report was, commissioned in part as sort of a response to calls during the 2020 election for court expansion, for other reform measures more structurally to the court. Do you think the ethics disclosures have altered that conversation any? Do you see any movement or progress on that front?
I think the major progress that we're seeing is with the other judges. I think if you look, for instance, at the recent response to what I call the Scalia trick, Justice Scalia had a trick of getting free vacations by having the owner of a resort extend to him a personal invitation to the resort. And then he would accept the invitation, he would go, he would enjoy his nice free vacation, and he would not disclose. And the only possible reason not to disclose the freebie is because you consider it to be personal hospitality, which is like going to visit your family. So the Judicial Conference took a look at this problem of the Supreme Court permitting a justice to fake personal hospitality by obtaining a personal invitation from somebody he'd never met, but happened to own a resort he wanted to go to. And they just blew that to pieces. They wrote a very, very strong correction so that the Supreme Court can't keep doing that. So that's just one signal out of the Judicial Conference. They have other questions pending. But I think by sending such a strong signal in response to the Scalia trick, they have credentialed themselves as a place where they're willing to do some serious work to help redeem the Supreme Court from itself.
And that sort of takes the pressure then off of court expansion and more stringent measures to sort of address the court?
I think that probably takes some pressure off. The problem is that even if you were to improve the ethics of the court, its pattern of decisions, the extent to which they conform to the interests of big Republican dark money donors, the damage that they're willing to do to ancient doctrines like judicial precedent, the fake fact finding that they indulge in to get to the outcomes that they want, that all remains a very, very significant to have to address. It's not just the ethics mess, it's the substantive wreckage that they're creating, which partly results from the ethics mess, but is also partly just the product of them being a captured court selected for those outcomes.
And this is something that I come into a lot in my own reporting, and it's something that I think a lot of other legal reporters counter either. There seem to be an awful lot of these cases by right-wing legal activists that are filed in states like Texas, where they get one judge to hear the case, and they almost, by accordingly, guarantee how it will come out. Has Congress looked into that? I mean, the Supreme Court, the separation of powers issues are there, but the lower courts, that's much more clearly in Congress's ambit.
Yeah, we're starting to. The Department of Justice actually has filed lawsuits to stop that judge shopping behavior, and they have not succeeded. I think they filed 3 and they lost the first 2. So if they go 0 for 3, then I think we need to step in. If they win and it sets a new rule, I think that helps. But it's not just one judge in one division in one district in Texas who you can find and therefore pick your forum and therefore get a free win. Often it's actually the groups that lobbied for that judge to get his appointment that are now before that same judge making the argument. So there's a big conflict there. But separate from that, you can go all around the country and you can find cases in which right-wing advocacy groups have brought cases in which they rush into court and they say, please, I want to lose. Please let me lose as quickly as I can. And then once they've lost, they rush up to the Circuit Court of Appeals and they say, please, we want to lose. And we want to lose just as quickly as we can. Now, anybody who's been around courts knows that that is bizarre litigative behavior. And the only reason that makes any sense is if you think that you have a Supreme Court that is politically ready to deliver something that you want, and you're rushing to get in front of that friendly forum, not as real litigation, but to get a political goal achieved. And you see that all the time in cases like Cedar Point and Friedrichs and Janus and others, where sure enough, the special interest behind the litigating front group got the big win that it wanted, having rushed to the court, losing and losing and losing on the way, deliberately losing on the way.
Yeah, that seems to characterize just about every environmental case I've seen them rule on recently as well. I know that the court is by design and sort of by function the least democratic branch. So, the ordinary American voter, ordinary citizen, they look at this and they might feel a sense of powerlessness. What can ordinary people do if they're concerned about this issue?
Well, I think speak up and speak out is important. I think if you're a member of an advocacy group, if you're a member of a civil rights organization or an environmental organization or a labor union, you need to make sure that the group that you're associated with is taking on this issue of a court that is rigged against you and have some real force. And then I think, there are things that Congress can do. Make this a voting issue and give us bigger majorities, and we can help solve these problems. At the moment, it is telling that Republicans are rallying to defend the indefensible in terms of Supreme Court behavior. And I think it's telling that the very same big donors that packed the court with these justices and that are getting these big wins are also funding the Republican Party. And so the Republican Party is instinctively responding to defend the captured court for big donors. And in that political environment, we can be political too.
Well, thank you so much for joining us today. I really appreciate it. We are very glad that you're able to take the time. I know certainly Senate's busy these days with things like the debt ceiling. So we're always happy that you could take the time to do this. Also, we want to thank listeners. Oh, I'm sorry.
I was just going to say, it's very important that Americans have a court that is actually behaving like a court and that they can have confidence and faith in. And until we restore that, this is important too, just like the debt limit is important.
And we'll be back, or at least I will be back, on June 15th. We'll be discussing for our second part of our series, voting rights, election integrity, other issues facing democracy that are before the court this term. There are multiple cases the justices are set to rule on, and hopefully we'll have some answers on them by then. Until then, please feel free to sign up at tnr.com/events. You can also view replays of this or other events on our YouTube channel. Thank you so much for joining us today. We really appreciate it, and we hope to see you again soon.